Hi, my name is Attorney Walter Rudolph Hnot III. I'm with Disability Resolution PA, an Orlando, Orange County-based Social Security disability law firm. I want to go ahead and begin with kind of a thing that popped up over last week, which is where a disability attorney contacted me and said, why the heck are you giving, they used a little bit more aggressive language, but why are you giving away a lot of the information on how this system works? Because it is hurting, our ability to make money off of the system. Which he is correct in part, but not very correct. And here's why. The disability system is getting harder and harder to win benefits, and it requires more and more law knowledge to be able to go ahead and do well in it. It's also becoming trickier, which means that the average person might make a statement that, if they're not careful with, will go ahead and blow their claim out of the water very quickly. So what we end up with is a situation where I don't think it's getting easier to be found disabled. I can point to probably 12 reasons why right off the bat that just pop in my head, which is weird that I had 6 and 6, like here's them and here's them. So here's my thing. I'm gonna read to you guys an opening statement that we would use as part of a hearing, and you guys can gauge from that how simple you feel that this actual system is and where it stands on it. So I'm going to read for you the law. And then my point with it is, just before I get the relevancy of it, is that I don't think me giving you this information, to me this is the basic stuff. I don't think this is high level. I don't believe that giving you the basic stuff is going to make you guys significantly less likely to hire attorneys. I think out of 10 people that were looking at hiring an attorney, 1 will say, no, I'm not going to hire an attorney, I'm just going to do this. But I think probably 3 or 4 will say, now I definitely need an attorney. In fact, I think this helps disability attorneys because it gets people knowing what they should be saying to the SSA, it gets people knowing what they should be doing in order to win their benefits, and it gets them more pumped up about having an attorney that can act as their buffer, create briefs, create all this stuff for them. I think it frankly helps attorneys. I could be wrong, but I think it helps attorneys. And I mean, it doesn't just help me because people watching like, oh, he knows his stuff. A lot of these other attorneys know their stuff. A lot of this law, to be fair, a lot of this law is not how much you know. Like, you need to know a lot. But the reality is this, it's a lot of heavy lifting and hard work. It is. People are like, oh, it's just administrative. If it's just administrative, then there's a problem because your attorney or you are, or some legal or non-legal representative is doing it incorrectly. So my point is, let me read you this and then you'll kind of understand what we're going for. This is a basic Fed Middle District-based remand from Central Florida, and this was ALJ denial, Appeals Council denial, Fed Middle District, remand back to AC order back to ALJ. Your Honor, I wanted to thank you for the continued service to the American people during the virus outbreak. We're in COVID right now. Please stay safe and healthy. The 3/22/19 Notice of Award Letter for SSI dictates that this remand review will encompass a potential SSI period from 2/15/14 to 3/21/19. Since the DLA is 06/11 and there are no new earnings via the detailed via the detailed summary or new hire, they're requesting the withdrawal of the T2 claim. Additionally, please amend the AOD to 9/2/14, as this writing will contain AOD analysis anchor points for your review. Furthermore, the ERE only shows a Title II claim under adjudication. We're requesting that the SSI claim be added back to the ERE for adjudication purposes, as there is no indication in the record as to why it was removed. You will notice that the original 7/12/17 ALJ unfavorable letter on page 16 notes that the T16 claim was adjudicated as part of the original judgment. Please also take note of the 16A Fed Middle District complaint during the Section 1, Paragraph 1 notation as to the SSI benefits being included throughout the appellate process. Your Honor, this remand occurred due to the cleaner/housekeeping being included in the available Step 4 PRW without necessary specificity of physical requirements or demands, along with contradictory pulmonary irritant restrictions. The 12A MDI, via the 2014 error on page 11, notes severe primary dysfunction of major joints and secondary severe affective disorders. Please also note that the 10D summary earnings shows SGA up to 2006, with questionable SGA in 2005 and 2007, which via the 17A District Court remand decision explains our concern with the specificity as defined in the 2017 unfavorable decision for the SGA-based housekeeping limitations. The top 5 impairments on this claimant are anxiety/panic attacks, depression/bipolar, joint dysfunction, carpal tunnel syndrome, and chronic homelessness. The date of birth is 9/28/63, which at the application date, PFD, makes the claimant 50 years, 4 months, and 18 days on the day before she was found disabled in 2019. The claimant will have been 55 years, 5 months, and 24 days. Please consider the following AOD anchor points, which help solidify post-drug abuse 9214 AOD with the below sedentary Dr. Torres RFC. And then I go through the anchor points as to why we have a good basic alleged onset date that we're amending to. I don't think that this stuff is so easy that answering these little questions is going to make people want to hire an attorney less. I think, frankly, look, there's always the DIYers, right? The DIYers like, I'm just going to go do this thing myself. And some of you are so severely impaired that hopefully you won't get a denial. That's the reality of it. I don't think, for a lot of reasons, that people would be unwilling to hire an attorney for this field of law. In fact, like the overall arching theme out in the public domain is, if you don't hire an attorney, you're probably not going to be found disabled. Is that accurate? No, but it's a careful no, because it is accurate in some regards, which is unfortunate that it works that way. But so does criminal law. So does personal injury. Personal injury is more the amount that you get. Obviously, you have an attorney, you get a significantly higher amount. So, a lot of people are like, oh man, I negotiated 20 grand out of them. Woo! And I'm sitting there going, dude, like, what were you thinking, But they don't know. And remember, different people feel good at different levels, When somebody's like, I just got $100,000. I'm sitting there, I'm like, you're an amputee now. Like, what are you talking about? You got $100,000. This is like a multi-million-dollar claim. Or my favorite one, you'll see it in Orlando all the time. He got me $1 million. And when you go read the case file, you find out that that's not actually the person who was injured. The person who was injured died. They're not on this earth anymore. They are suing on behalf of the estate of the dead person. And the remainder man, the person who basically takes the remainder of the suit, right? When it comes in, they get a settlement, or a judge goes ahead and said, okay, this is what we're doing, yada yada. Or you might have a jury depending on what time of claim it is. Basically, if it's a person where a person, if it's a claim where a person dies, that's not usually $1 million claim. That's usually significantly more than that. But the big box firms publish that, and people don't know what certain claims go for, and so they're like, that's cool, I've got money, I didn't have money before. It's sad that I've lost this person, but I'll move on. Here's my money. And I hate to say this because it's going to make me sound bad with you guys, but $1 million is not that much money. And I'm not saying that because I have millions and millions. I don't. I still have student loans, and I have hundreds and hundreds and hundreds of thousands of dollars of student loans because I'm a white male. That's the bottom line. I got screwed in that system. When I went to school, I'm old enough where females that were white were actually considered a minority. Just let that sink in. Let that sink in for a minute. But white males basically were considered, we took on all the debt. They charged us significantly more so that other people didn't have to pay as much. So it sucks for me and the government really should forgive a large percentage of my loans, because the black kid, the Latino kid, the Asian kid, the white females, the Jewish kid, and I have a Jewish mom. I was the president of the Jewish Law Student Association at Barry Law for 2 years. All right. Anyways, point is, going back to the original theme, this little information, this is a roadmap. It's not like the end game of how to put a ribbon on winning this thing. It's not how to negotiate with that specific judge to get them to approve you. You guys don't know that. You're never going to know it. You're never going to have it. You're never going to have it in your bag of tricks. You know why? You don't go in front of these judges all the time. You don't know what they want. You don't know what they're looking for. You're never going to have that. When you're going in front of a judge, you're like, oh, yeah, I'm going to do this, and this. No, you're not. You're going to try it. You think it's going to make a difference, but you don't know what they're actually looking for. Oh, I asked somebody, is it an attorney that practices in front of that judge all the time? No, it's my friend. Then you're an idiot. And I don't mean it in a mean way. Sometimes you guys think I'm really egotistical about stuff, and I'm not being egotistical. What I'm saying, you're an idiot for listening to a person who's found disabled who thinks he knows how the system works. Do you get that? Some of you don't. Some of you are going to DIY this thing and get denied over and over and over again, and that's fine too. America's filled with lots of those people, and they're good people because sometimes they invent stuff. But I don't think doing these videos hurts disability attorneys from getting business. I just don't feel that way. It's too complex. There's just too much stuff going on. I don't feel that way. Anyway, this is a video to explain to those other disability attorneys who feel that I shouldn't be making these videos why I do make these videos. I like to help the community. I think the community needs help, and I don't think this stuff is so high level that, you know, basically it's going to take away the job of the attorney to do it. Now, the big box firms, they do, in my opinion, I have to put that in there, I can't use profanity, a job leaving much to be yearned from the wonderful experience of where they're sitting there going, the attorney never ran questions with me, they never built the claim, they never advised me on what to do. You know, that's the problem with these big box firms. It's just however many claims come through the door, they'll go ahead and process them, but they're not going to do anything on them. And then which ones stick based upon the basics that they can do, kind of like McDonald's line, ketchup, pickles, mustard, there you go. That's what you end up with. So, you know, I guess what I'm saying is don't listen to your idiot friend who basically tells you this is how it works. And now there's another thing I want to put in this, though. There was a guy that I made a video about where I reviewed his video, and he was definitively explaining the greatest secret to disability law that was out there, which was essentially to collect your medical documentation when applying and submitting it. That, now that I think about it, was, and I did a very kind review of him, but I don't think that I actually did a good thing there. I should have been a little bit harsher about what he was selling. And I need you to understand this. Collecting all of your medical evidence ahead of time is fine, but that does not equate to a finding of disability benefits. Not even close. The disability documentation, right? The evidence, the protected health information, we call it PHI, that you submit to the SSA, if it does not show that you are severely disabled, mild, moderate, severe, or extreme, and then remember, some listings require extreme tendencies, but if it doesn't show severe and you collect all your documentation ahead of time, you've just proved that you're not disabled. What do you mean? I thought that's how I was found disabled, if I get all my medical evidence ahead of time. No, that's not how it works. The easiest way for people to see that is the blind, doctrinal theory, which is there's a blind guy. He goes to the blind clinic. The blind clinic says he's blind. He submits that documentation when filing for the SSA benefits. Boom, he's blind. The blind clinic says he's blind. He's found disabled. That's the easiest way to think about it. Now, for every one of you guys that does file and then gets a denial, and then you're like, I don't understand, what the hell? It's because it's far more complex than you could ever really imagine. And I know that you're sitting there going, well, I'm brilliant and I can figure this out. Where's my tape and where's my stickies? Look, I don't know it all. Not even close. The other day, I had a judge that doesn't like me. It's just the way it is. Who blew my mind because she saw something in the record that I read twice. She read it once, and boom, she saw something that I totally missed. It's just too complex, guys. It's just too complex. Okay? I do this crap all the time, and I miss stuff. Right? It just is what it is. So my point here is, I really do not feel that doing these videos hurts the ability of essentially future, or attorneys to get future claims. I just don't see it that way. Maybe I'm wrong. Put it in the whatever, the bio area or the comments or whatever that section is. Just put it in there. If you think I'm wrong, that's fine. Maybe I'm giving away too much information. I don't know. Maybe I am. And then maybe if I'm doing that, maybe I should curtail it. I don't know. But if you guys knew how complex this stuff was, like really knew, not like this cutesy stuff like, hey, what are the top 10 things I should do to get approved for Social Security benefits? What's the most important piece of evidence of winning Social Security disability? Like, if you knew how surface level this crap is, you would become very frustrated. It's like taking a person and giving them a picture of a high-level modern chip, all little connections, all the little microscopic thingies on it, right? And saying, cool, you got it, go apply for it. It's just not, you know what I mean? You don't know what all these things are on a chip. Microchips that come out today, I mean, they have microchips and microprocessors that you cannot see with the naked eye. Let that sink in for a moment. The entire computer's CPU is smaller than what the naked eye can see. Just let that sink in. And now they're working on making quantum computing into that. Which, by the way, takes two particles, makes them, act similarly. And that gives you, I guess, what would be called faster than light, even though we can't have that, immediate response, right? You're no longer sending light down, a glass, fiber. You are making an object mirror another object, which equates to instantaneous, which is faster than light, and what we make it into is a logical analysis for computing, What do we do? Do we use binary to compute in that? Do we have a new code language? What do we do, Anyways, so that's my answer, and I'm sorry this video is way too long. I'm going to go back to the fun surface level stuff now. That way we're all happy. I'll catch you a little bit later. Have a wonderful day, and thank you so much. Bye-bye.